and ask you to hold questions until the end. Following the presentations around 10 a.m., we have left about 30 minutes or so for questions and answers. This is the spot in this little introduction thing where I'm supposed to insert a personal story. If I started talking about federal land management laws to insert my personal little story at this point, you guys wouldn't get out of here before 5 o'clock. So I am not even going to do that, other than to say this has dictated the last 8 years of my life. Our first presenter this morning is Tori Sondheim, more commonly known as Tori Sunshine. She brought a lot of help to us to all of our counties with the natural resources and public lands issues. She's going to go over NEPA and then some ESA. Tori is our in-house public lands person at NACO. We're very lucky to have her here at NACO, therefore the Sunshine name, to help us out on our public lands related issues, especially because she has a legal background in natural resources law. Tori has been at NACO for just over a year and works closely with Nevada's counties to help them leverage their role in the planning and management of public lands for multiple use. Tori's professional background includes water law, environmental law, tribal law, and land use planning. She earned her bachelor's degree in business administration and communications and organization and management from Emory University, and her law degree from McGeorge School of Law. She then went on to receive an additional degree in water law. Tori is a member of the bar in California and plans to take the Nevada bar in 2017. Tori, take it away.
Yeah, go ahead. Good morning, everybody. Today I'm going to start with a brief overview. It's not that brief. It's an overview of NEPA and the ESA. And I hope that by the end of this presentation, you'll have a good idea of what they are, when they matter, and how you can get involved. The National Environmental Policy Act says, all agencies of the federal government shall include in every recommendation or report or proposals for major federal actions significantly affecting the quality of the human environment a detailed statement on the environmental impact of the proposed action. All that says is when there are major federal actions, that federal agency has to prepare a detailed statement, which we'll see later on is an environmental impact statement. And one of your handouts is actually a table of contents for an environmental impact statement, and the other is the NEPA process. So I hope these handouts will help guide through this presentation. The purpose of NEPA is just a planning tool, and I think that's really important to recognize and understand. Federal agencies just have to consider the impacts of their proposed actions. They have to decide whether a different action would result in a better final decision, but they don't have to accept any of those other proposed action, any of those other actions that they would consider. And an important point is, again, this only mandates a particular decision-making process, not results. So the agencies can be held responsibility for failure to abide by the process, but you can't say at the end that you don't like their conclusion. So what happens if a federal agency doesn't follow NEPA's decision-making process? And I think this is another important point, is that the agency may have to stop implementation immediately, depending on the case, and they will have to go back and fix whatever the court decided the agency did wrong. The new final decision, it could be exactly the same, and they simply have additional information to back up that decision. But ideally, it would be different, and that would be the reason for challenging something like that. And another important point is, to challenge the agency action, you have to participate in the process and offer your input. You cannot allow the agency to go through the whole process and in the end say, we didn't like what they did. The agency and the courts will come back to you and say, okay, well, what was it that you asked the agency to do? And you would have to say, I didn't participate, and then you wouldn't be able to enter into any kind of challenge. So the key component of this is the environmental impact statement. It is the document the agency develops to consider the impacts of and alternatives to the proposed action, which could result in a different final action. So the main contents of an EIS, which is listed in your table of contents, is there's a statement of purpose and need, which the agency has to focus on what it's doing and why it's doing this action. Alternatives to the action, so the action that they want to do, they're preliminarily they say we want X to happen. So they'll look at, well, what are some other options? If I didn't do X, what if I manipulated that a little bit and changed some design aspects? Or what if I did a different project altogether and that still achieved the purpose? To analyze all of the environmental effects of all of the options that they've come up with. Then finally, mitigation measures. So looking at those effects and saying, what are the measures we could take to reduce the effects that we know are foreseeable from this project? And then finally, there is an important public involvement component, and the agency does have to respond to that public involvement. The final decision has to be a reason based on the analysis in the EIS. So whatever is not considered in the EIS, the agency actually cannot make a final decision. So again, if you don't participate and you don't ask the agency to consider certain things, if they didn't consider it, you can't ask at the end. When is an EIS required? An EIS is not always required. It's only for major actions. So it has to be a federal agency. So it would be the BLM or the Forest Service, Fish and Wildlife Service. Whenever they proposed a major action, so maybe a plan, it could be a project, a permit or a license over a large piece of land, they have to decide that major action would significantly affect the quality of the human environment, and that has a whole list of standards. And then no categorical exclusions apply. There are categorical exclusions, so statutory, a list of things in the statute that we decide for policy reasons we don't have to go in and do an environmental impact statement for. If it's unclear, the agency could prepare an environmental assessment just to decide whether there will be significant impacts. And if it decides not, they'll file a finding of no significant impact and we'll just move forward with their action. And note, there are several lawsuits over agencies' decisions not to develop an EIS. Often they want a different outcome, or maybe someone doesn't want the plan to go through and knows that if the project has to prepare an EIS, maybe the agency would decide not to do it. There are a lot of different options there, but I think a key factor is courts typically, if it's questionable as to whether it's significant, would favor, say, go ahead and do an EIS. There is a special role for local governments in NEPA. It's called Cooperating Agency Status. This is the official mechanism for counties to participate. You have the opportunity to shape, ideally, the outcome of the project. And at this point, at the very beginning of scoping, it's really important to select the appropriate individuals that you need to be involved in this assessment. That way you can ensure the agencies are being guided and that real consideration is being given to the impacts associated with that. So you might even decide that you can't be a cooperating agency, that you don't have the staff and it's too time consuming. Even that it's still important to let the agency know why you can't be a cooperating agency, and you still need to comment during the comment periods for the general public, because again, that's all you have standing for legal recourse. If at the end of the day the agency's project doesn't seem well reasoned, or they take a left turn from a project that you thought was okay, if you want to challenge that, you have to again participate, and that participation is either through cooperating agency status or by commenting. So invest the time, if you can, to be a cooperating agency. If you can't, write that letter, and this is your only opportunity to think about desired outcomes and engage participation. Next. The EIS process, and this is in your handout. Just to give a broad viewpoint, starts the proposed action. If there's an exclusion, they can move forward with their action. And if there is no exclusion, they look at do we have to make an environmental impact? Do we have to create an environmental impact statement? And if they do, then there's a specific process. They have to file a notice of intent in the Federal Register. Then they start the scoping process where they define the scope of what they want to do and list all the potential environmental impacts that might be foreseeable. And at that point, that's when public notice and comment comes in. And the public then can say, well, we want you to consider air quality or water quality, or we want you to consider the impacts on our county's road system, for example. The agency then develops a draft environmental impact statement, and there's another opportunity for notice and comment, for review and comment. So the agency will publish that draft EIS. Everybody gets a chance to look at it, provide comment. The agency has to look through that comment and make changes if they can to provide a final environmental impact statement, and then a record of decision. And once that record of decision is signed, as long as there are no challenges to it and if they don't lose, the agency moves forward. Well, no, if the record of decision is signed, the agency will start moving forward with their action and implementation. So the EIS, part of the EIS, and we went through this before, was the purpose and need. The alternatives. The alternatives, I think, are the most important component of the EIS, and something that we need to be very, very careful about. So there's always a no action alternative, and that says if we don't do anything at all, what will be the impacts? So there is a baseline level of impacts that we have to consider, and what are we really doing here? Are we making a big difference? The preferred alternative is usually what the agency says, this is the action we want to do. And then they have to analyze all other reasonable alternatives. The agency decides what these alternatives are. Each alternative must be rigorously explored and objectively evaluated. And the number just depends on the project. So the agency has to, at the end of the day, describe what it eliminated from consideration and why maybe those alternatives weren't going to suit their purpose for the project. And this is really important for alternatives. The alternatives and their components are the agency's only options. So this is the local government's opportunity to offer a desired outcome. So if for example, there's a project and you're looking for them, so if there's a project and it's in a certain area and you think maybe the project would be better suited for a different area, or maybe the project should be designed differently, this is your opportunity to offer that outcome. And the agency can put it in their EIS and evaluate that alternative and its effects. And then in the end of the day, that means the agency is allowed to adopt what you're offering. While the agency might mix and match alternatives in the end, if it's not here, the agency is not allowed to use it in their final decision. So if at the end of the day you say, well, it'd be really great if you did something different, and they say, well, we can't. We didn't analyze the impacts of doing that something that you're saying now. List of common environmental effects. I'll just give you a second to look at those and say that this is where studies are important, especially for socioeconomic impacts, because this is where the agency is doing a cost-benefit analysis. And if at the end of the day, it's going to be too high a cost, then maybe the agency isn't supposed to take that action. Or maybe if there are more benefits, and sometimes it becomes political and certain impacts become downplayed when they should be fully considered. And I think it's fair to say that socioeconomic impacts is a key issue, something that we've dealt with here. Next. Mitigation measures. Finally, you look at all the impacts and the agency says, so what measures do we need to mitigate it? Do we need design alternatives that would decrease emissions, different aesthetic modifications, just, any kind of mitigation? They do not have to specify or identify mitigation measures at the time of the action, but they just have to discuss what mitigation measures might might be available. So this is a good place to offer recommendations for mitigation measures, because maybe you think a mitigation measure doesn't need to be as harsh, or maybe you think it needs to go further, or that you have an option. And finally, there are circumstances where the agency has to produce a supplemental environmental impact statement. If there are new circumstances or information that are significant and relevant, or if there are substantial changes in the proposed action. So again, if you didn't have an alternative that you wanted to offer during the alternatives analysis, and later you come back to the agency and say, you know, I really think the project should be over here instead of where you have it. If the agency didn't analyze it, they'll have to produce an entire new supplemental environmental impact statement, analyzing the impacts of that alternative that you're offering. And it might be difficult to get the agency, to convince the agency to do a supplemental impact statement. If they don't want to do the other action, they think their action is fine, they're not going to go through all that trouble. Or if there's something that changes last minute within the agency, we might say, you need to do a supplemental environmental impact statement. You didn't analyze the effects, and we don't even understand what your final action is. How to enforce NEPA. So how, at the end of the day, do you make sure that the agency does this process so that you can participate? Only a court can tell the agency it violated NEPA, and to sue, you have to participate in the NEPA process. I think that's the most important takeaway from this entire, law. Common legal challenges: the agency didn't follow the procedure. They didn't prepare an EIS when they should have. The contents of the EIS were inadequate, or the final decision had nothing to do with the information provided in the administrative record. Your scientist said X, and then you just decided Y. Final takeaways. Planning decisions can be made that address local concerns and federal land management's priorities. Local government and stakeholder engagement is crucial, and counties have a better opportunity to affect the outcome of a project when they're fully engaged. But we recognize counties often, especially in Nevada, lack the capacity or studies to fully engage in this process, and it causes a lot of frustration and conflicts, and this is an area where I think there's a lot that we need to do, and some of those things might include socioeconomic impact baseline data, forging better partnerships with the scientific community if you can't pay for consultants, or being willing to pay for consultants, or having that funding set aside if that's possible. And then finally, robust land use planning efforts. Finally, this is a list of NEPA reading materials, and this presentation will be available, so you can always access those. It's statutes, regulations, CEQ, and remember, each agency has its own NEPA handbook. So if the BLM is the lead agency, you have to go to the BLM's handbook to see how they're going to handle NEPA, and same for Forest Service or Fish and Wildlife Service. Okay, now we're moving on. Thank you. Now we're moving on to the Endangered Species Act. The Endangered Species Act policy purpose is species are extinct or in danger of extinction due to untempered economic growth and development. These species are of aesthetic, ecological, educational, historical, recreational, and scientific value to the nation and its people. That is the purpose of the Endangered Species Act. So it's saying, because of that, we want to conserve species using all methods and procedures necessary to bring any endangered species or threatened species to the point at which measures provided pursuant to this chapter are no longer necessary. So the whole point is conservation. We want to conserve the species. We do not want species to be listed. We want people to provide efforts so that species don't become endangered or extinct in the first place. Some argue the ESA should only apply to man-caused species, but the ESA applies no matter what. And we see that a lot with greater sage-grouse, for example. You might have habitat succession or predation, some species fighting out other species. It's just the way it is, and it's important to know when you're dealing with the ESA. An endangered species is, and these are definitions in the statute, so this is what the law says, any species which is in danger of extinction throughout all or a significant portion of its range. So the agencies who are tasked with listing species are the Fish and Wildlife Service and the National Marine Fisheries Service. We don't deal with nymphs here because that's for marine mammals and fish, and the Fish and Wildlife Service deals with freshwater fish. So we deal here with the Fish and Wildlife Service. And the Fish and Wildlife Service determines the significant portion of its range, and they have their own science and agency staff to make these determinations. A threatened species is any species likely to become an endangered species within the foreseeable future throughout all or a significant portion of its range. The agencies have to use the best available science to inform their decision, and I just want to note that while this means the agencies still have to follow certain procedures, the agencies are given a lot of discretion here. An agency has met the standard as long as it used information readily available at the time it made its decision and explains how it used that information. So when you're saying whether or not the agency used science, the scientific community has, I think, a lot of issues with this, and I think a lot of people do in general, but it's just another important thing to remember. The agencies have their own staff and their own scientists, and I think as a policy consideration, courts are not likely to say that they want the agency to use a particular scientist. They just don't want to get into it. It's not important. They want to just make sure they are using scientists and they are making reasoned decisions. Key measures of the ESA. These conservation measures apply to listed species. So until a species is listed, the ESA isn't an issue. State conservation measures can be used to avoid a listing. If you have adequate measures, it may mean the Fish and Wildlife Service doesn't need to list a species. I think that's really important too. And then once listed, Section 7 of the ESA says all federal agencies must consult with the Fish and Wildlife Service to determine whether federal action must be altered to prevent jeopardy to a listed species or adversely modify its critical habitat. So what that means is if the BLM or Forest Service were going to do an action and that action happens to be within critical habitat, they have to consult with the Fish and Wildlife Service. And then the Fish and Wildlife Service might end up putting restrictions on that final project. Listing factors. What do the agencies need to find to list a species as endangered and or threatened? Present or threatened destruction, modification, or curtailment of its habitat or range. And these are really technical, but this is what the statute says, so I'm just gonna read them. Overutilization for commercial, recreational, scientific, or educational purposes. Disease or predation. The inadequacy of existing regulatory mechanisms or other natural or man-made factors affecting its survival. Consultation example. So let's say the greater sage grouse was listed as an endangered species. The Bureau of Land Management and Forest Service would have to consult with the Fish and Wildlife Service each time they initiate an action. Maybe that's a permit, maybe it's a lease, maybe it's a land use plan amendment. But certainly, and I think most actions that are subject to NEPA, that would mean it's going to significantly affect the environment. It probably also triggers consultation with the Fish and Wildlife Service. So then the result is the Fish and Wildlife Service would probably impose design or other restrictions or mitigation requirements on permit operations or development. They'll say you can't build here during the winter, or a lot of things that we see in some other sage-grouse restrictions. Common legal challenges to the ESA. Should the species have been listed? So it shouldn't have been listed in the first place, or it should be delisted, or it should have been listed in the first place. And it's a very controversial issue for counties, especially counties and states who have implemented conservation measures, who have put a lot of money and funding and resources into conserving a species, and then all of a sudden you have an action against the Fish and Wildlife Service that says, no, those shouldn't matter, you have to list the species anyway. Second, did the agency use the best available science? Did the agency follow their proper procedures? And then was the decision based on information in the record? Does it seem like somebody made a backdoor deal and all of a sudden came up with a decision that was counter to what all of their scientists were saying? I know this is, county efforts do matter to the ESA, and sometimes that gets lost. But there is a section of the ESA that says agencies have to take into account those efforts being made by states or political subdivision to protect the species. So if you have predator control, protection of habitat, or other conservation practices, that should be considered in listing. And the Fish and Wildlife Service has developed something called a PECE report. And it's the policy for the evaluation of conservation efforts. And that report is something the agencies themselves produced, and they said, we are allowed to rely on conservation efforts when they meet these requirements. That's what this report says. And they say these requirements show a species listing may not be warranted if the county has a conservation effort that is sufficiently certain and that it will be effective and implemented. And there are a whole lot of standards under that, but I think that's important to keep in mind if you want to come up with a conservation strategy to follow that report and work on it if that's something that's important to you. Finally, takeaways. Local area working groups or projects, if developed using these criteria and the PECE, effectiveness and implementation certainty, they're an effective way to take local control over conservation efforts. And county wildlife plans should be considered in listing decisions, so if you do choose to develop a wildlife plan, you might consider that. Finally, here are some reading materials for the ESA, and that concludes NEPA and ESA, and instead of taking questions now, we'll take questions at the end.
Thank you very much. Next, we're going to have Attorney Laura Grenier. She's a partner at Davis, Graham and Stubbs, LLP. Ms. Grenier's practice includes complex commercial litigation and regulatory work, including governmental affairs. She also represents numerous mining clients on a variety of natural resource issues, including Nevada water rights law, permitting, and public land issues, the policy issues affecting mining. Also, Ms. Grenier is currently representing a handful of Nevada counties in their lawsuit regarding the BLM and the U.S. Forest Service's sage-grouse management plans. Prior to joining Davis, Graham, and Stubbs, Ms. Grenier was a partner at a larger Nevada law firm. She also served as a law clerk for the Honorable Proctor Hugh Jr. Did I pronounce that right? I hope I did. When then Chief Judge of the U.S. Court of Appeals in the Ninth Circuit. She's a graduate of the University of California Davis School of Law, where she was a judicial intern for the Honorable Robert Rose, Supreme Court of Nevada. Laura is going to go over FLPMA with us and help us to understand how that law works. Laura, welcome and thank you for being here. Are you with us?
I am. Thank you for the introduction and thank you for having me this morning.
Wonderful. Take it away. It's
Thank you. Good morning, everyone. Is there feedback? I think.
Laura, we're not getting Laura, we're not getting very much of what you're saying. You're disappearing on us.
Yeah, I feel quite a bit of feedback on my end too.
Maybe she called on the wrong number.
No, we've got that turned off. Would you consider hanging up and calling back in just to see if maybe it's a connection issue? I don't know what else to try.
Of course. You bet. You bet. I'll do that.
Thank you.
I'll do that.
Corey, well, we're waiting for her to call back in. Is there any way we can get have you send us an email or whatever of the slides you just?
Absolutely.
Yeah.
And I think this presentation is being recorded too, so we'll also.
She'll be on the website.
The recording of this workshop will be on our website, as will Tori's PowerPoint
Okay.
presentation, as well as the handout she provided this morning.
Okay, great.
Hi there, this is Laura again. Is that better?
So far, go ahead, try.
Okay. But, so the Federal Land Policy and Management Act, which we all refer to as FLTMA, was enacted in 1976 with the purpose of establishing a comprehensive approach to managing public lands in a way that would protect the scientific, scenic, historical, ecological, environmental, air, atmospheric, water resource, and archaeological values with a fundamental purpose of recognizing and achieving multiple use of public lands. There are a number of primary uses of the public lands identified specifically in FLTMA. Those include mining, grazing, right-of-ways, and within right-of-ways we come across the issue many of you are very familiar with, we refer to as RS-2477 roads. And I'll get back to that in just a minute. I want to step back for a moment to give you a little bit of background about how FLTMA came to be, to really set into context what was intended by the Act. We all know how very much control the federal government exercises over public lands, especially in the West and especially in Nevada, given how much of our land here is federally owned. So it's a significant issue, and FLTMA is known as the Organic Act. It's the act where Congress gave the executive branch the authority to manage the public lands. Absent the act, that authority is vested solely in Congress under the Property Clause, which gives Congress plenary power to manage all lands owned by the United States government. So FLTMA is the primary delegation of that congressional authority to allow the executive branch, the Department of Interior's management, and particularly here the BLM's management of those public lands. Prior to FLTMA, what was happening was there were a lot of withdrawals going on, and I know many of you are very familiar with the withdrawal we're currently experiencing under the recent Sage-Grouse Land Use Plan Amendment that stemmed from that. But again, the authority to withdraw lands from mineral entry or put lands off limits to any other multiple use really is solely rests with Congress, unless Congress delegates that authority. Well, prior to FLTMA, there were a number of withdrawals of public lands, mostly by the executive branch, quite often, many times by the president, but in the 1940s, the executive branch, in 1952, the president delegated all of his withdrawal authority to the Secretary of the Interior. What happened over the course of about 1909 to 1952 was a number of withdrawals, one of the largest of which was in 1909 that withdrew about 3 million acres of western lands that folks thought had a great amount of oil potential. That resulted in the Midwest oil lawsuit. And in that case, the United States Supreme Court actually said it recognized that the power to withdraw lands and manage the public lands was vested solely in Congress through the Constitution, but essentially said, well, we've had the executive branch undertaking these withdrawals for some time, and Congress has not stepped in and stopped the executive branch from doing so. So the court's reasoning was, well, Congress has acquiesced to these executive branch withdrawals, so, we guess it's okay. Otherwise, Congress would step in and do something. What that prompted was, in 1964, Congress initiated an in-depth review of public land management policies. And so the Public Land Law Review Commission was formed and created to look at the withdrawal issues. There was overlapping lands that had been withdrawn. There was a lot of confusion over how the public lands were being managed. And so this commission was formed to serve as an advisory board to assist Congress in reorganizing and creating a structure for public land management. And that report resulted in a recommendation for a comprehensive system of public land management and recognized some failures in the program. That report really is what culminated in and resulted in Congress enacting FLTMA. And Congress tried to adhere to the recommendations of that committee's report. The reason that context is very important to understanding FLTMA and what Congress intended and how far, what authority actually Congress delegated to the executive branch through FLTMA is that, again, this was a reaction to what many people saw as an overreach by the executive branch and with putting so many acres of our public lands off limits to multiple use. And so FLTMA was intended to take us all back to a more managed or put us in a situation of more structured management, recognize, these lands should be open to multiple use, and that was the primary goal, and also really rein in this withdrawal authority. And so with FLTMA, I think what we have was a very clear line drawn that, there had been some question prior to FLTMA of what authority the executive branch had to conduct withdrawals of public lands. And I think post-FLTMA, it's very clear that Congress delegated limited authority under a couple of sections of FLTMA, 202 and 204, for withdrawals. 202 is the process by which the BLM undertakes its resource management planning. And they have very broad authority under Section 202 to conduct land use planning, and that's the process that many of you or all of you are very familiar with that we've undergone with the greater sage-grouse. With that land use planning process, the BLM has the authority and, in fact, the directive to look at the overall status of the lands, look at multiple use, emphasize multiple use, knowing and recognizing, of course, conservation is a goal, but also recognizing that the nation has a need for mineral extraction, that there are commercial uses, livestock grazing that are important to management of the public lands and also to the economy and communities, local communities, and allow for recreational use of the public lands. So there's supposed to be a balancing of those multiple uses. And when the BLM actually legitimately engages in that balancing of multiple use, then the agency is entitled to a significant amount of discretion in its ultimate decision of what's the appropriate balance. So when you are looking at legal challenges, if you get to the point where you've had a process that followed the statute through the land use planning, there was appropriate public participation, there was appropriate participation by local and state governments, and you're just not happy with the outcome because you think the agency just got the balancing wrong. It's a difficult challenge because it's an uphill battle. You've got what's called Chevron deference to the agency's discretion, and there is a pretty good amount of discretion vested in the agency to conduct that balancing and make its decisions. What happens sometimes, though, and a very important aspect of FLTMA, and I think one of the important factors that Congress considered and expressly included in FLTMA, is that this would not be, this would be a cooperative management of the public lands, recognizing the importance of state and local community governments, and this is where you all come in. FLTMA mandates what's called a consistency review process, and so the Secretary and the Department of Interior and the BLM have an ongoing obligation to keep themselves apprised of the local and state laws and policies and plans that are in place that relate to the issues being addressed in the land use planning exercise. So, for example, you all have your own land use plans within each of your counties. Many of you have incorporated into those or created your own greater sage-grouse conservation plans, and it's a requirement of FLTMA that all of the work that you have done at a local level and all of the rules and policies put in place at a local and a state level be considered and try to be reconciled with the federal planning that is being considered to put in place to these land use plans and the resource management plans. Ideally, that works, to focus on with a recognition that, while there may be some similarities, these issues are very local issues. How the lands are being put to use, what's needed for conservation, how to be good stewards of the land really falls in the hands of the local folks who are dealing with the issues day to day on the ground and know how to best balance. And on a related note to that, so that there's supposed to be work with the counties, with the state, and there's also really the resource management planning process under FLTMA has always been really a local process where you have your field office really overseeing, your field office of the BLM really overseeing the process and helping guide the proper scope and the parties involved and making those sometimes very difficult balancing decisions. Of course, the state director ultimately gets involved with the decision, and you may have input on a more regional basis. But historically, this has, I think, very intentionally and properly been more focused on local interests and management. And some of you, I know you've had other workshops and you're very familiar, but and I won't get sidetracked here, but at this point I do want to mention, efforts are underway known as BLM Planning 2.0 to completely rewrite the regulations that govern the land use planning amendment process. And what you see in the proposed rule that's out is really a shift. It's a shift from what I've described as an obligation fundamentally for the federal government to make sure that there is appropriate collaboration with local governments and state governments, and a federal obligation to know what the rules and plans and policies are in place in the local and state governments and reconcile conflicts that may exist with what's being proposed at a federal level. And that is being shifted to really more of what I look at as a top-down approach in the proposed rule. So that's a pretty important thing to keep on your radar and be very involved in, because that could really change how the planning process is carried out. Going back to, I'm running out of time here, so I'm just going to hit some highlights, but going back to, again, looking at multiple use, another important aspect probably for many of you is what I mentioned, rights of way and RS 2477. So as some of you may know, RS 2477 refers to an old mining law, actually, that was trying to encourage folks to come out west and settle and make use of the public lands. And allowed for creation of access roads. That authority for creation of new roads was repealed, but in FLTMA, any rights for existing access at the time was preserved, and that's how we have come to know RS 2477 as the mechanism by which, if you can show existing use, you can establish a valid existing right, and if there is an attempt by the federal government to stop use of that road, you can go through an adjudication process, which many of you may know can be very time-consuming and very expensive, but it is there to prove continued right to make use of that road. And within that, I made reference to valid existing rights. That's another very fundamental and important concept under FLTMA. Part of there was kind of a recognition here that Congress would delegate this authority to the executive branch. It's a tremendous amount of trust and power within FLTMA to manage the public lands, and it was very important as part of this bargain, if you will, that all valid existing rights, including grazing rights, mining claims, oil and gas leases, water rights, and rights of access granted under 2477 would be preserved. That has become a pretty significant issue, especially recently with some of the land use planning exercises that have been undertaken around the greater sage-grouse issues. FLTMA is. It entails a lot of details, a lot of concepts. Generally, the basic standard for managing the public lands is called UUD. So the fundamental purpose for BLM, again, in carrying out management of the lands to ensure multiple use, is also to take actions that are necessary to prevent unnecessary or undue degradation of the public lands. And so, as you look at issues under FLTMA and the land use planning process, that's really the scope of the BLM's authority, is what they are doing to manage the lands, to preserve the lands and ensure avoiding unnecessary and undue degradation, or is it going farther than that? But that should always be the objective in mind. That's the scope of the legal delegation of authority. With respect to, I know Tori mentioned legal challenges with respect to NEPA and the ESA. Under FLTMA, probably the most relevant legal challenge with respect to you all, again, is going to focus on that consistency review process. And again, under FLTMA, you do have important rights for the consistency review, and that, again, just harkens back to the federal government's obligation to make sure that there has been a collaboration. And there's been a look at, hey, are we unnecessarily encroaching on or conflicting with the local laws? You all are sovereigns, and you all have sovereign powers, and fundamentally, I think we recognize that counties and local governments are the ones who have to be entrusted with ensuring the public health and safety, and that includes, managing your roads and managing land use planning and managing conservation at a local level. And that is fundamental, and that was, I think, preserved and recognized in FLTMA. And so, I'll take you back to, yes, FLTMA gives the agency a great amount of discretion in their balancing, but FLTMA also recognizes and preserves your sovereign powers and responsibilities, and ensures that you have an important role in that process. And that is, Lorinda made reference to the handful of counties that have challenged the sage-grouse land use plan amendments, and that is one of the fundamental concerns that we've raised in that lawsuit, is that there were significant issues raised by the counties, and this LUPA has tremendous impacts on our way of life here in Nevada and in your counties, and that the process was not properly followed in accordance with FLTMA. So that is one of the big issues we are litigating there. And with that, I think I've taken up my time, and I know we wanted to leave some time for questions, so I'll turn it back over to you, Loretta.
Thank you very much, Laura. And Tori, both, you had great presentations. We do have some time for some questions for our presenters. If you are in a remote location and you have a question, please jump in also. But remember to keep your phone or your video system on mute unless you do have a question or a comment. And with that, I'll open it up.
Yes, I have a
Don.
question.
Yeah, go ahead.
In the county, we are required to keep track of all of we have the mining claim maps. And are those lands that, even though the mine is gone or not operating, is that still public land according to the Supreme Court? Rights and claims of others exist is not public land. That's something I've been thinking about a lot, and I don't know how it can be public land anymore.
So who's going to answer that, Laura or Tori? Laura, do you have an answer for that one?
Sure, I can take I'll take a shot at that. I think if I'm understanding the question correctly, what you're saying is, where we have public lands and there are mining claims on those lands, and that's probably what many people consider the primary use of those lands, and yet there's been a mineral withdrawal, which means the federal government has said there's no more mining on that land, at least for 20 years. Do those lands remain public land? Is that the question?
Yes.
Okay. So it's a great question. They do remain public lands. All lands under the 1872 mining law, all public lands are open to mineral exploration, mineral and entry for mineral development. What happens when you go through a withdrawal is the federal government is closing those lands to mineral entry. And so while they are closed to further use for mining, unless you have a valid existing right, and so what that means is if you have a proven resource that you have identified before the lands were withdrawn from mineral entry, then you can survive that withdrawal and you can continue mining. If you don't have that, the lands continue to be public lands and controlled by the federal government, but you can no longer conduct mining on them. They've basically been set aside for something the federal government has decided is a more important use of that area. So with the example of the sage-grouse withdrawals that are going on right now, the federal government has said, these lands that are within the SFA are so important to sage-grouse conservation, we are considering whether we should close them to mining for the next 20 years.
Did that answer your question, Don?
Then why are we required to keep a record of all the mining maps if they no longer exist?
Laura, can you hear Don?
I didn't quite hear.
Would you repeat that again?
Then why are we
If the
still
counties
required?
are the counties still required?
Yeah, why are we required in the county to keep a record and keep all of the old mining maps if they don't apply anymore? If it's just, it would be a waste of time and money if they don't mean anything anymore.
Yeah, so I think that's a good question, and it could depend on the circumstances. I mean, one thing I would be concerned about is it's important, especially to those who have those mining rights, that those records stick around, because you can raise the argument that you have a valid existing claim and that your right to continue mining should be preserved, but that takes some proof, and that proof would require historical information such as those maps. So I don't know that closing, even if there's a mineral withdrawal, and I'm not sure those maps could go away.
Yeah, I would see it much like keeping records for birth records or marriage records or divorce records especially, even though it's gone away. You still need the records. Do you have other questions, Flora? Or for Tori?
Yes, with the Taylor Grazing Act preserved all pre-existing rights. FLIPNA preserved all pre-existing rights. So if we claim something that happened prior to the Taylor Grazing Act, it's still legal for us to do, right? Or wrong?
Excuse me, it should be. It should be. I think with with any valid existing right, it sort of relates a little bit to your prior question. Similar, for grazing, for mining, for RS 2477, your ability to protect your right as being valid and existing will depend on your ability to demonstrate, the history behind it, how it was put to use, and hopefully some documentation of that.
I have one here for you. How does the greater sage grouse habitat protection measures tie into all these laws? Is that a question for you, Tori?
It's for both of us. I think, Laura, did you want to start to answer that, or do you want me to take it?
Sure. I'll give up just a little bit of background, and then maybe I'll hand it over to you, Tori, because I think it's a great question, and it's a very interesting recent example of how all three of these tie together. So the background here is that this issue actually started under the Endangered Species Act. Some environmental groups brought a lawsuit against the Fish and Wildlife Service, saying that they were going about their listing decisions for a number of species, I think about 250 species, too slowly, and they wanted a federal court to force the Fish and Wildlife Service to hurry up with some of these decisions. That lawsuit resulted in a settlement agreement in which the Fish and Wildlife Service agreed to a schedule with the environmental groups in this litigation as to when they would make listing decisions for, I think, about 250 species. So that settlement agreement set a deadline of September 30th of 2015 to make a listing decision on the greater sage grouse. There had also been, there had been a look at the greater sage grouse to see, should this be a listed species? And initially the agency said no, it shouldn't be a listed species. There was a lawsuit challenging that. And then the agency came back and said, well, it's a species that is warranted for listing but precluded. And what that means is, if we had limitless funding and resources, we would list it, but we don't, so we have to prioritize, and so we're not going to list it. The settlement agreement, interestingly, did not leave the Fish and Wildlife Service with the option of continuing with that status of the species to keep it warranted but precluded, which is a status expressly set forth in the Endangered Species Act. So there's some question as to whether that was it was legitimate to eliminate that possibility. But in any event, it put the Fish and Wildlife Service in a position where it had to just say the bird will either be listed or not listed. And that is the decision, as a result of that, and great concerns that arose that the species would be listed and that listing would have very dire effects, the BLM embarked on this unprecedented land use planning amendment to develop what they said would give regulatory certainty that there would be conservation of the species. And then with that background, Tori, maybe you want to fill in a little more from where we ended up.
Sure. And when those agencies work together to get regulatory certainty, I think that's where FLIPMA came in. So Fish and Wildlife told BLM, you can you can include regulatory mechanisms within your land use planning, within your land use plans, then we can be assured that certain things won't happen on that habitat, and therefore those species is sufficiently protected, and those conservation measures exist, and then we don't need to list the species and go through those consultation requirements every time there's an action. So when the BLM decided, okay, we'll, and we want to help you conserve the